Okay, good afternoon, everyone, and welcome to the Surrogate Session. I'm Christina Ramirez, and I am your host today with Surrogate Heather Darling and Attorney John Klein. Today's topic is what to know about trusts and estate planning. Before we start, just a couple of housekeeping items. All participants are muted, but you have the ability to ask questions throughout the program by typing them in. The panelists look forward to answering your questions after the presentation. You should see the Q&A on the bottom right side of your screen, and you can just type in your questions. I will see them, and then I will present those questions to our panelists at the end of their presentation. Also, just so that you know, a recording of today's session will be made available on the Surrogate's website at a later date, and that most likely will be Monday or Tuesday of next week, and that is at morrissurrogate.com. Now, let me introduce to you our panelists. Surrogate Heather Darling. She is an accomplished attorney. The surrogate received her bachelor's degree from NYU in finance and international business and earned her law degree from the Seton Hall School of Law. Heather is a former Morris County freeholder and served as deputy of the board. She was elected in 2019, and Heather is the first woman surrogate here in Morris County, and she took office in January of 2020. The surrogate has as her guest today, John M. Klein, Jr. John holds the distinguished AV rating for his professionalism and the caliber of his legal work from the Martindale-Hubbell, the premier directory of legal professionals. John specializes in general tax planning, corporate planning, and business mergers and acquisitions. John's legal experience includes advising in estate and tax mitigation planning, wills, trusts, and other instruments. John brings with him many years of experience. He adds a wealth of knowledge along with the surrogate on today's important topic. As a reminder, please use the Q&A box to send in your questions, and I'm now going to turn the program over to the surrogate and Mr. Klein. Thank you.
Thank you, Christina. Welcome, everyone. John, welcome. Thank you for joining us today. Thank you for joining our presentation on trust and estate planning, which I know is going to offer some great insight into this area of law, which is a little mysterious to some. Many people don't believe that they have an estate that requires a trust because they don't think that they have much money. But when you have a house and you've managed to save a few assets, a few dollars here in Morris County, you frequently find that you have more, or your heirs find that you have more than you originally believed that you did. So this is something that I believe is very important. I think based on the number of people that have signed up today, obviously people are very interested in the topic. So this is part of our ongoing educational series. Previously, we've done a lot of work on wills. But when we talk about wills, trusts often enter the picture, enter into the conversation. As such, I think it's critical that today we talk about trusts and we'll compare and contrast them with wills so that people can understand how they work together in a general estate plan. So we know that people don't tend to do estate planning when they're younger for one reason or another. They tend to wait, and sometimes with disastrous consequences, because if you have a child and something were to happen to both parents, if you needed to appoint a guardian, things along those lines, it is critical. But why, John, in your experience, do people tend to wait until later in life to do that planning?
I think, Heather, a good reason for that, the best rationale I can offer is that in many cases, people, when they have young children, they're spending a lot of money. When they send children to school, they're spending a lot of money. And then after the children are grown and move out of the house, they can accumulate wealth. And so what happens is people's wealth builds up over time. And when they're in their 50s and 60s, they're saving and they start to think about estate planning to deal with their assets. Of course, that is not to say that young people who don't have a lot of assets should not consider it. They should consider estate planning. In particular, what you said, if they have young children, they have children with special needs, if there's a divorce that they're coming out of, those are all times where I think it's important to consider estate planning.
So, John, we see a change in trend today. Millennials tend to wait longer to have kids. Gen X and Gen Z sometimes eschew having children. They tend to be more focused on their own lives and their own self-direction. Do you see a change in the horizon as to when these people will consider undertaking estate planning or when they should?
Yes, I think it's a broad change in the demographics. And sometimes Gen X and Gen Z and Gen Y, they don't get married. Okay, they have children, but they don't get married. And so the entire way we have lived and things that we have done is starting to change with the young people. And so oftentimes what I'll do, if somebody has young children, I'll prepare like a living will and a healthcare document when they attain 18. And then nothing much happens after that because they're on their own and they're not necessarily thinking about estate planning. So again, I would say in many instances, in particular, if this young couple does not get married, but they have children, they should both engage in estate planning just to cover the base with their children. Okay?
John, can you define very basic terms? What is a trust and how does it differ from a will?
Okay, good question. So there's a will, and a will is effective and becomes effective when a person dies, and it governs her estate. So it says take the assets and collect them, pay the estate tax, if any, or any other taxes, and then distribute the assets to the beneficiaries. The trust can say, well, don't do that right away. Let's take money that we put into a trust for the benefit of my son, because he doesn't spend money too wisely. And so the trust document, which can be contained in a will or it can be a lifetime trust, that is going to have provisions saying the assets in this trust will be paid out to my son over time. He may get the income, and it may say the trust can be invaded for his health or educational needs. It can also say when later on, if he attains a certain age, gets married, or finishes college, he may get an amount payable to him, like a stipend from the trust.
So, John, essentially a will is a document that directs a distribution of someone's assets. And a trust is a vehicle, an entity like a corporation that will hold somebody's assets and direct the way that they're managed. And you've got the trustee as sort of your asset manager that then does whatever the trustee directed in the document creation for the term. And then at some point in the future, the assets will be distributed either to beneficiaries or to remaindermen. Okay. And there, of course, there are several types of trusts, and we're not going to get into all of them today because it would just be too consuming. But why don't you tell me a brief example and when you would use each of the following? First, tell me about a special needs trust. What is it and who needs it?
Sure. Okay. A special needs trust is a kind of trust that we often prepare for a family member who has special needs and may be under state care or have state benefits being made available to her and him for his maintenance and well-being. Okay. So in that type of a case, if assets from an estate flow to that person, usually that will result in her becoming disqualified to get those benefits. And part of the problem here, Heather, is oftentimes it's not that you mind having the disqualification. It's just once that happens, how do you get back into the system?
Right.
And the application process.
It's very difficult.
Daunting and hard.
Yes.
So the special needs trust is designed to arrest the money from going directly to the child. It's held by a trustee and used for special kinds of things, not health and welfare necessarily, but rather luxury.
Quality of life issues.
Exactly. To take care of them.
And what about a minor's trust? What's a brief example and what is that for?
A minor's trust was created many moons ago, and it's a kind of special simple trust that you can create for the benefit of your children or your grandchildren. You put money into it, and that money is always eligible for the annual gift tax exclusion. Okay, and there was a hurdle with that because back when they started out, we didn't think we would be eligible for the annual gift tax exclusion. So a minor's trust under 2503C is a type of trust that facilitates making gifts to minors. There's a lot of competition now because you have 529 plans, which are a different topic altogether, but have tax favored benefits. The 2503C trust has actually a high tax cost if it earns interest, but not if it earns dividends. And there's all these little tricks. So a 2503 minors trust is used sometimes where someone just wants to do something very basic, very simple. And they say, I'm going to start putting money into this trust for my son, 15,000 a year, 30 if you're married, and it builds up over time.
30 if you're married, meaning husband and
Husband
wife
and
can
wife.
each contribute.
Correct. You're still right. And the one detriment sometimes with the 2503C minors trust is when the child is 21, the child has to have the right to get the money and take it all out. So sometimes that's not the best time for a child to have access to a large amount of money.
So now that you touched on that, spendthrift trust, explain to me
Sure.
then how that would come into play.
Good. A spendthrift trust is a trust where the focus is on a long-term period for a child. He may be a young adult or she may be an older adult. And usually it's in a case where someone has the proclivity to spend a lot of money quickly. And we know sometimes people are good at spending 101% of what they have available, or 101% of what they make. And those are the kind of people that a spendthrift trust is designed to help by not giving them all the money right away, because if you do that, it may get spent in a short period of time. So a spendthrift trust might be used for a child, or a cousin, or a brother, or someone that you're trying to help take care of without giving him or her all of the money in one lump sum. Okay? So these are all like arrows in the quiver of what we might use for people for their estate planning.
So where a minors trust terminates at 21, a spendthrift trust could go on throughout a person's lifetime
Exactly.
in order to preserve assets so that they can't overspend and they do have something left to care for their own needs.
And their retirement, absolutely. That's correct.
So basic categories of trust include revocable, irrevocable, testamentary. Can you tell our audience what a revocable inter vivos trust is about? Where one would use that?
Sure. So a revocable trust means it can be changed and altered by the person who creates it. So if I create a revocable trust, I may be doing it because I'm starting to forget where I keep my money, or I'm starting to forget things. I don't want to lose track of my money. And I feel I need somebody to help me manage and control my finances. So a revocable trust says, I put the assets into it and I can count on my brother, friend, cousin to help manage the trust. Okay. It also says I can change the terms of the trust if I need to for one reason or another. This says I can get all the money back if I need it. Okay. So a revocable trust is not used for estate planning because the IRS says if you can put money in and take it out, we're going to include it in your estate because you control it. In this case, if I set the revocable trust up, I'm not doing it for the estate tax benefit. I'm doing it to manage and control the asset and protect either myself so I don't lose the assets. And there's always people out there who ferret out and pick on seniors, whether it's the scam saying we've got your grandson in jail and you can bail her out. I've had a client send huge sums of cash money to people like that, a smart client. Okay. So sometimes as we get older, people need some help.
So John, let me ask you a question. Now, guardianships are kind of, they used to be very broad. Now they're very limited to allow self-direction in the life of an individual. So if you believe that you are temporarily at a loss, but you may regain your faculties, would a revocable trust be applicable in a situation like that, where you wanted to protect your assets from yourself until such time as you regain your faculties?
Yes, it could. And it might be that I said I'm going to have some surgical procedures and I may not be able to come out of it well. It would take the assets and hold them forever if needed, or until I die. So I'd be protected. But if I'm better in 1 year, then I can say, okay, once I'm better, I can take the money back out and have it not have the trust involved.
Now, John, what is an irrevocable trust?
An irrevocable trust is kind of the opposite of a revocable trust. When you put money into an irrevocable trust, you cannot change it. Okay?
Can I exchange it? If I put a house in,
Right.
can I get an appraisal and put the value of that house in and take the house back out?
Yes, most trusts, if they're irrevocable, they still have a provision called an exchange of property. It says if the amounts are the same. So if you put a house into the trust and it's worth 300,000, and you have 300,000 of GameStop or AT&T stock, you could put the stock in and take the house out. Okay, that's called an asset swap, and it's contained as a kind of trust we call a grantor trust. Okay, and that's a beneficial provision because it gives the person that creates the trust, even though the trust is irrevocable, she has some options available to her.
So it's not only like property. When you're exchanging GameStop for a house, the house has a relatively defined value, where real estate, although it fluctuates, does tend to fluctuate far less than a stock may in the course of a year. So
especially if it's GameStop.
very true. So that being said, there are no limitations then on the type of property that can be exchanged within a trust,
I would say that's absolutely
as long as the value is the same. That's the key
Right.
component. But it can cause the value of the trust to swing wildly, where GameStop could shoot up or down,
Right.
versus a home, which may change by 100,000 or so a year, but there's a sort of a defined situation where over time it's going to appreciate, but based on lack of real estate available as the population grows, right? But it's also going to depreciate over time, potentially as the home ages and requires repairs and things along those lines. And what about a testamentary trust, John?
Sure. Well, a testamentary trust is a trust that's contained in the will. Okay, so many times, if we think about a typical estate, it usually is opened and closed within a couple of years. Okay, so let's assume I have the situation with my daughter, and I'm thinking she is susceptible to investing her assets in her spouse's business, and it's on his fourth business, and we don't know if that's a good thing. So to protect her, I can say the assets inuring to her, rather than going to her outright, will go into a trust. The trust is going to say to give my daughter the income every year as needed. If she needs money for her health or maintenance, she can take it out. If she needs money for her children's college or orthodontics, the money can come out. So you're kind of protecting her so that this, with the fund that she gets, will not be dissipated too quickly. Okay? It's also a way to put money into a trust where you can say, I want this money to be used to pay for my mother's care throughout her life. And then when she passes on, it can go to a charity or it may go to my children. So there's other things you can do with a trust over a long time.
So now you just mentioned charity, which brings me directly to my next point. So thank you for that. Now, we frequently hear of Mark Zuckerberg and Warren Buffett and other very big names with trusts. And typically those trusts are charitable trusts and they're designed for significant tax benefit. Is that accurate?
Yes, you can garner a significant tax benefit by having certain kinds of trusts that say you're going to put assets into the trust today. You may retain the right to get income from the trust, but ultimately that trust asset will inure to the charities maybe in 10 or 15 years, and you're allowed to get a deduction. If a person puts in appreciated assets, they don't have to pay tax when they put that in, but they still get a deduction. So there's ways to do that. Now, some of the people also, we don't want to forget Bezos or Gates, they put money into trust, but then they qualify the trust as private foundations. That means it's dedicated to charity, but that person who creates it and puts in a couple $1 billion decides when and to what charities the monies will go. They have to give away at least 5% a year, but they have leeways within that.
So now talking about taxes, let me swing around on that question a little bit. What are generally the benefits, tax benefits, or consequences of a trust?
Okay. If a trust is structured properly as an irrevocable trust, and I put money into the trust or stock into it today, that trust, if the asset that's in the trust appreciates significantly, whatever is in there is outside of my taxable estate. Okay? So the functionality of using an irrevocable trust can be to save estate taxes. Okay, it can also be to protect assets if I'm thinking about the fact that I might ultimately need Medicaid or something like that, if I set up a trust and it's irrevocable, I do it 5 years before I apply for Medicaid, I may be able to not have to count those assets toward my asset base. So there are things to do with irrevocable trust. And I would say right now, because the estate tax exemption is so high, people are not running around doing trusts as much as they used to, because the estate tax we have an $11,700,000 exemption right now, which will probably change. And because that's so high, most people aren't as interested in estate tax planning.
But with regard to Medicaid, with the cost of long-term care facilities being what it is, and of course you and I know, you go to your doctor, you get a pre-approval, you go get this procedure done, next thing you know, you have a bill for $5,000 from a procedure that was covered by your insurance and was pre-approved. So now when you can buy long-term care insurance, but do you really want to go to a $20,000 a month long-term care facility and find out that your long-term care insurance doesn't cover this, that, and the other thing, is being left destitute because your money is being spent for medical procedures for which your spouse is responsible. So although you don't experience the tax benefits anymore, you did touch on this Medicaid situation, which certainly is one impetus as to why you would want to use an irrevocable trust. What other reasons, given the fact that irrevocable means you can't take it back, and also we put it in there, you have to appoint a trustee other than yourself. So you lose control of those assets. You can't go to your trustee like you go to the bank and make a withdrawal. So now giving you money is in the discretion exclusively of your trustee. So there's a trust document that says they will follow the terms of the trust in the distribution of the funds. But there's no specific direction because, of course, that would give you qualified income, which could exempt you then from benefits. So what reasons, knowing that these hindrances are out there, would somebody have, other than Medicaid, to put their assets into a revocable trust? Are there situations like asset preservation, malpractice, insurance, or there are things like that that come into play?
Good point. So if it's an irrevocable trust, and I put assets into it today, and I'm a lawyer, a doctor, or I own real estate, and there's a judgment that gets entered against me a year from today for malpractice, negligence, or what have you, that asset base in the trust is not subject to my personal claims. So you remember when we said the trust is a separate entity, like a corporation, what that means is if I have a judgment against me, it doesn't adversely affect what's in the trust, right? So it's a way of protecting assets and taking them out of harm's way. Certain times I would say doctors in certain professions where they're prone to being in litigation are sometimes big end users of trust, okay? Lawyers and property owners, we try to be careful and have insurance, but you never know for sure. So some people want to create a trust and put the asset beyond approach by creditors, and an irrevocable trust will do that under the right circumstances. It's not for everybody, and not a lot of people need it necessarily, but people who have accumulated wealth that's at risk and who have a profession where they say I might be exposed to something, right, are sometimes good candidates for the irrevocable trust.
I think one of the saddest things that I used to see when I was practicing in this area of law before I was precluded as surrogate, was when an exceedingly senior citizen, someone in their late 80s and 90s, would come in with all of their faculties, and their spouse had just entered a long-term care facility, and they hadn't done their planning, and they were in my office crying, asking, what can I do to not be left destitute? And unfortunately, because of the 5-year look back that you spoke of, it's literally too late to do anything because you were responsible for your spouse's medical debt. So that to me is the glaring reason why anyone and everyone who has assets should consider at least an irrevocable, because After that 5-year look back, or before that, when you haven't planned properly for that window and it's too late, and you find that someone in your family is now going to be left destitute so that all of your assets can go to pay medical bills that would have been covered had you not had those assets exposed. It's terrible. So, John, lightning round, because we're about
Okay.
5 minutes. I'm looking here, we're 4
Okay.
minutes from
Okay.
12:30, and we're gonna go into the Q&A. Corpus, what is a corpus in a trust?
A trust has a fund, and when I create a trust under my will or irrevocable during my lifetime, I put assets into it, a house, stock. What I put in initially is corpus. It's sometimes also known as the principal of the trust, meaning that's the actual, we sometimes use the analogy, it's like the tree. The tree has fruit that grow every year, and I can say this is something to take the income, which is like the fruit each year, but don't harm the tree. So corpus is like the tree or the principal portion of what goes into the trust.
And then what is the income?
The income is what's generated from that. It can be dividends, or it can be interest, or it can be capital gains. And the income then can be distributed out, in accordance with the trust instrument, to the beneficiary that I've named in the trust document. Okay?
What is a beneficiary?
The beneficiary is the lucky person who is entitled to get assets, income from the trust, and he or she can get the income. Oftentimes they can get principal if it's needed for their health, welfare, or medical reasons. Okay?
What if there's one beneficiary and the beneficiary passes away? Then it goes to who?
Goes to the remainder person who is usually defined in the trust instrument. It will say, this is for the benefit of my son, daughter, but if he or she should die before the full payout of what's in the trust, it goes to this person, who we technically call, it used to be called a remainder man, we're starting to change it over to remainder person, okay, to be gender neutral. And it can be a child, another child, or anybody really, or it could be a charity. Okay?
So, John, is it correct to say that a trust typically terminates upon distribution to remainder?
I would say yes, and so a trust has a life, and if I say this is going to be until my child attains the age of 45, and at some point around 45, the trust will pay out and it will terminate. Cease to have an accounting every year and file tax returns.
Okay, 2 more minutes. So, what is the net worth you think someone should have, a minimum net worth to make a trust worthwhile?
Well, it's a balancing act. If a person has very specific needs for a child, perhaps special needs, or wants to make sure their child that does spend a lot of money does not spend it errantly, that person may not have a lot of money, but they may be a good candidate for a trust. Okay? The one thing that we sometimes talk to people about when we're doing this type of thing is, who are you comfortable with? Do you have somebody that you know, and her integrity is good, and she has some financial acumen, and she can help, maybe knows the child and knows what's right? That's kind of the inkling of what you might have for a trust for somebody who may only have $200,000 or $150,000. It's a little bit of money to put into a trust, but for that person, it accomplishes a very important result. Okay?
So, top 3 reasons. Just give me 3 words. Top 3 reasons to create a trust.
Estate planning, okay? Protecting assets from unknown risks that I might incur, or protecting my beneficiaries from them taking the money out. You know, in New Jersey, we have a very good statute that says if there's a divorce and you inherit, the inheritance is not part of the equitable distribution. But if a child inherits,
And they commingle.
They buy the house together, they're not going to go out and do what they're supposed to do. Then what happens is it does become subject to distribution, whereas the trust does not.
So you touched on this before with the $11.58 million exclusion, and of course that's not triggered in many circumstances.
Right.
But you and I go back quite a few years, and we know when it was $1 million.
Right, in New Jersey was 625,000.
Yeah, I remember it well. So that being the case, and we'll reserve why. So given the recent government stimulus packages and the national debt being what it is, give me 1 minute or less. Do you have any predictions as to what will happen with this $11.58 million federal tax level as we go forward, and this debt needs to be repaid.
Well, I think we're gonna have tremendous debt load problems because we're spending trillions of dollars here and there and every year. And while we have good reasons for stimulus, and it also makes a lot of sense to talk about infrastructure, what happens is this has to be paid back. So I'm of the opinion that the 11 point, it went up to 7 million now because of the CPI. I'm thinking that they go back down. I know Mr. Biden has already said 3.5 million might be the right number. And he also said 5 million. I don't think it's going to 3.5, but it may go down to 0.5 million. Okay. So people, in some cases, if they have significant wealth, they do well to consider estate planning, while these exemptions are still very high to be used, okay, to shelter their gifts.
Perfect, thank you. Christina, I'm going to go back to you for a while with the Q&A. I know people from the audience generally have a lot of questions, and John and I know the material, so we know what we're talking about, but you know, people may have listened to what we said and have very specific questions on that. So let's hear what the audience wants to know.
Yeah, we have a number of questions that have come in, and I'm going to just kind of go through them here. First question is, in the case of a special needs trust, if the special needs person is released from being a ward of the state, will the trust still apply?
Well, usually special needs trust starts out and says this trust is only for certain non-maintenance needs for my child or whomever. If the child ceases to need the assistance from the state, okay, you can have a provision that would in effect say at a later point in time, the trust could cease to be a special needs trust. It could either be paid out to beneficiaries or it could continue with more easier to work with provisions in the trust, say giving the income to the child.
So John, you can include a provision in a trust that indicates that the trust can be reformed by the trustee so that it continues to meet the intended purpose of the trust. So for example, were tax laws or something like that to change, and the trust document itself now violated certain provisions of the newly reformed tax laws, by reforming it, the trustee then could continue to serve the grantor's goals. Is that accurate?
Correct. Under the Uniform Probate Code that we've adopted now, trust can be in effect modified so long as the key element in this is that whatever you do, you're not interfering with the original intent of the person who created the trust. And it gives New Jerseyans a fair amount of leeway to change as circumstances change.
Perfect. Christina?
Okay. So I have a couple of questions along this line. What is the difference between a 2503C minors trust and a UTMA account? And it might be helpful for you to explain what those two things are and then say what the difference is.
Okay. The 2503 is the minors trust, and that's an actual trust agreement that's set up for the benefit of a child. That's the one that we said before, when they attain age 21, the child can take the money out. He has an option. You can take the money out or leave it in, okay? The Uniform Transfer to Minors Act is a provision in New Jersey that says I can transfer shares of stock without even a trust. I transfer them and put them in the name of my spouse for the benefit of my daughter, okay? So I would then take stock and register it in the name of my child. It would be under my child's Social Security. However, my wife, in that instance, would be the person who controls the account. Okay, and that can be, it's a very easy and cost-effective way. If you don't have a lot of assets, you can move some assets down and get them into somebody else's tax bracket at a very cheap cost, because all you're doing is registering the stock either with your broker or someplace. Okay. One quick add, just because this is very relevant. People sometimes think if they put things into Uniform Transfers to Minors Act or 2503 trust, minors trust, they're going to be taxed at a lower rate. However, the Internal Revenue Code now says if a child is under the age of 21 and has unearned income like dividends and interest, that's going to be taxed at the child's parents' tax bracket, because you don't want parents to take their income and spread it down into lower tax brackets. So there's a whole, when you go and talk to a professional and ask them for guidance on this, these are the kinds of things that they would review and guide you, okay? But they're two different things, and each of them has the, like I like to say, they're in the quiver and you can pick one out. You want to pick the one that's best suited to somebody's individual circumstances. Christina.
Okay. Earlier you spoke of a minor's trust and the 529 accounts and the gift tax.
Mhm.
Do you get the same benefits in putting money into 529 that you do into a minor's trust as far as gift tax?
Yes, and sometimes you can actually get a better result. A 529 account is an account that says it's in some respects similar to an IRA. It's an account, you go to a broker, you go to a bank, you set up the account, and it has a child, usually the first child and the primary child and the secondary. And if the money in the account is used for that child's college, then the money comes out and it's income tax free. Okay, so if you start when the child is 1 year old and keep funding a 529 plan, you could have a lot of money in that by the time your child is going to college. So the 529 in that case is actually somewhat better under certain circumstances because there's no income tax on that, where there will always be an income tax on the 2503 minor's trust.
Now, John, can you elaborate on that? If the child doesn't go to college,
Okay.
what is the benefit to the 529 plan?
Let's assume a child does not go to college. The worst case is you take assets and you're allowed to transfer to another child that may go to college, or the assets can come out. You would pay income tax on whatever has been earned. You would pay a 10% penalty. Okay, that 10% penalty is not a big deal if you've invested it for 22 years, let's say, and have not paid any taxes. Okay, so the 529 in some cases can be better. The one thing with a 529, you give up control over investing the account. You're not going to invest at the sponsor of the 529 plan. It could be like each state has one, and New Jersey has one that actually is performing pretty well. I guess another key aspect of a 529 plan, or if you're saying 2503 or 529, the 2503, if I have a small business, I might contribute stock in the business into that, but I could never do that with a 529 plan. Okay, so I think a 529 in some cases can be better. And I think I said before that the 2503 trust were all the rage going back 40 years ago, but now they have a lot of competition.
John, what's the benefit of contributing stock from a closely held business into any plan?
Sure. If I have a business and I anticipate, and in fact, let's say it does grow over time, I then have the ability to transfer, let's say 5% of the stock, let's say each of my 3 children, and maybe the stock is only worth $1,000 at that time. But later on, if it's a growth company and becomes worth a couple $1 million, then I've transferred it out and practically no estate gift tax.
Do my kids have control over the company if I do that, or can I retain control of the company?
Well, what you would probably do is have a trustee that you'd be comfortable with who would vote the stock. Okay? When I put stock into a trust, if I want it to be effective in an irrevocable trust, I cannot vote the stock after I put it in. But I can have someone whom I'm comfortable with, her or his direction as to how they would vote on stock in the business.
What about dividing into voting and non-voting shares?
You can do that. There's an intent, there's a benefit you can get if you create non-voting, which is generally speaking, if I get stock that's the same pro rata interest in the company, and 1 share is voting and 1 share is not voting, the IRS recognizes that the non-voting is not worth the same as the voting because there's no control.
So you'd have a discount.
You get a
twice,
discount. Yeah,
technically.
once putting it in at a low number, and secondarily, you'd have that discount because it's not voting stock. That would help.
And I would assume the voting stock, if it were a minority position, would also be at a discount because you've got a minority position.
Exactly. So you can sometimes do very well with the discount.
So the things that we're talking about, to the point here, to Christina and the audience, is that there are many, many practical applications of a trust, which is what I'm trying to elicit by discussing this with John now. the things that we talked about are an overview, but when you get into the nuances of what these vehicles really can accomplish, there's tremendous benefits to people. So it's something that you should always be aware of and be looking into.
Okay, so the next question is for a married couple with adult stepchildren. What is the best way to include them but protect the estate for the children of the marriage?
So this may be a second marriage for husband and wife, and they may have children, each of them, from the prior marriage. Okay, so couple of things. If in a case like that, they would both do well to have trust to govern their assets. So if I'm on my second marriage and I have children from my first, and my wife, who I'm married to now, has children from her first, we usually want to define how things will devolve. So we may say that some of, like the house will be a common asset, but income and assets that I've accumulated before we get married would be contained in a trust for the benefit of my children. Okay. Sometimes you say that the house will be maintained until the youngest of all children finishes up college. Okay? So trust would definitely be well indicated there. Sometimes that couple may or may not have a prenuptial agreement before they got married the second time. If they do, that may have provision to govern how assets will devolve. Okay, it may not. Okay, so you look at a situation like that, and if spouses are looking to be protecting their own children from the assets that they've built up, you'll sometimes say that those assets that each spouse brings into the marriage will maintain a separateness, but then income going forward while they're married together will be part of a common fund. Okay, and that can all be done with a trust. Might be a trust under the will, or it might be an inter vivos trust, depending upon the person's individual circumstances. Right? That's a good area to have a trust and think about it, even if you don't have a ton of assets.
Okay. So at what age should one create an irrevocable trust? Can this be done before either spouse is eligible for Medicare?
Yes, it can. The key thing is to remember that a irrevocable trust, you really can't change it. Okay, so depending upon a person's family circumstances, okay, and fiscal status, they're going to think through, do they want to have something that's irrevocable? If I'm a younger person, I may not do a trust today for estate planning purposes, but I may consider, and I say younger, I mean 60, 58, 59, okay? I may set up a trust for Medicaid purposes, and the timing sometimes to do that is sooner rather than later, because again, as Heather and I were saying before, if you wait, it's too late. So you got to plan to do something before you get close to the Medicaid event, okay? So that's a reason why someone might have a trust, okay? I don't think a person generally has to have a trust if they're 60 and for estate tax purposes, you know, unless they're over the 11,700,000. If they're below that, then one main reason would be for Medicaid reasons, okay? Or again, there's one other one which we talked about, to protect assets. If I've accumulated a fair amount of wealth and have a profession where I might have problems, that would be a positive indice or indicator that I may consider a trust. Okay, so again, it comes down to a lot of it is the individual circumstances of the person. Okay, and she would go over that and review it with an estate planning professional.
And an interesting aspect of that, John, we in the office have partnered with the Alzheimer's Association of Greater New Jersey to raise awareness. And if now people are being diagnosed based on family circumstances or other things, early diagnosis. So certainly if you had some early diagnosis of Alzheimer's or any other condition that may ultimately impact either a Medicaid status or the need for possibly early. Some people begin to show symptoms very early in life. So of course, based on diagnosis now is another reason that somebody might want to consider a trust earlier in life.
Sure.
As well as a special needs trust, like you said.
So And I think there are instances where they say Alzheimer's can be familial, or it's not hereditary, but if your parents have it, you're more likely to have
Right.
it. Those are then good reasons why somebody at a younger age would consider having an irrevocable trust based on the potential that they may need it for Medicaid planning.
Okay. So there's a number of questions around this subject. A will. So if you establish a trust, do you still have a will? Should you have a will? Do you have both a trust and a will? Can you speak about that?
Yeah, I have, being in New Jersey, where we have a very modern probate code and user-friendly surrogates, okay? I'm not a big proponent of people doing what we'll call revocable living trusts, okay? And that's where if you're in a state, and I won't pick on any state, but sometimes Florida is known, it takes a while to go through probate. So a lot of people in that state take their assets and put them into a revocable trust, okay? And the purpose of that revocable trust is to avoid having to go through probate in Florida, okay? Probate in New Jersey is quick and it's easy. And I know Heather's working on a program where she's actually going to be able to permit people to probate their wills from home, right? So they won't.
We actually have it, yes,
Yeah,
it's
yeah,
operational.
That's and I've used it for some clients, and it is extremely beneficial and easy, okay? So I oftentimes will see, and there are these companies that sell kits, and the kit is like a loose leaf binder, and you put it all together and you create a trust, and you don't need that if you're a New Jersey resident, in my opinion, most of the time. So the point of some trusts is to avoid probate. I don't think you need to try to avoid probate in the state of New Jersey because it's easy.
Possibly in the event of a caveat, that a caveat will be filed, somebody has made threat that if the assets are dispersed this way under the will, if you believe that there may be impropriety, somebody may have undue influence and you anticipate that you'll be filing a caveat. Perhaps if you're aware of an illegitimate child, something along those lines.
Kind of quirky things that can happen, but that's real life. So the benefit in a case like that, some people also say, well, if I do it with a revocable trust, then I'm not going to have to put into the public realm the provisions of my will. So if a person has a very peculiar situation that he or she doesn't want to be exposed to the public, a revocable trust can help them accomplish that objective. However, I think it's accurate to say most wills are online in the state of New Jersey, and I'm not aware of anybody spending any serious time looking at the wills. Okay, but that's a factor that somebody may talk to their planner about. Does that make sense for them? Okay, so the revocable trust, or this having a trust in lieu of a will, in New Jersey isn't necessary. And if I have a trust in New Jersey, sometimes the trust is just created under the will. And I'll say to clients, well, we don't have to do any trust today because there's no benefit from the state tax standpoint. So why don't you wait and create the will? And when you create the will, put a trust into that. That trust may say this is for the benefit of my son or daughter, and it's going to go out for 25 years to protect them. Okay, so there are differences there.
So continuing to talk about a will. So in a will, there's an executor. How is a trustee determined in a trust? And can the asset provider, if I set up a trust, can I be my own trustee?
Okay, so we're talking about the trust, and the trust will usually name the trustee. So if it's a living trust, that is one I do during my lifetime. I'm the creator. I put the money into the trust, and the trust instrument or document will say how the money will be invested and reinvested and distributed. And I have to pick the trustee. So in that trust instrument, I can name somebody who I know, who I'm comfortable with, who will be both good with investing money and knows the beneficiaries maybe. So he or she would then say, I'm going to pay this out in accordance with the trust. That sometimes the person may be pick today for the trustee's position may not be a good person in 20 years from now. And if I'm talking about a trust that can go on for a long time to track my children and pay them benefits, you may want to include a provision where somebody else could come along and become a trustee. Or you might say if the trustee were to become unable to serve, or the trustee herself or himself dies, you could have a provision to say this is the person, or you could say in that scenario, I will appoint a local bank to act as trustee of the trust. Okay, so the trustee is an important person. An ideal trustee would know something about finances and investing. He would know something about the beneficiaries. And I think just as importantly, it would be someone whose integrity you kind of know and can vouch for because you've dealt with that person. Right? So the trustee is a very important person.
So can you be your own trustee?
If you want to have an estate tax benefit, you cannot be the trustee of your own trust. Okay? The reason for that is the IRS says, well, if you're going to pass it out of your taxable estate, we want to know that you're not going to be continuing to control it. So in that scenario, that kind of a trust, you cannot be your own trustee. If, on the other hand, you have a revocable trust, if we're just using it to contain your assets, you could be the sole trustee of that trust. Okay? And then there's another type of trust where you can have two trustees, yourself, the grantor creator, and another trustee. And you could even have a provision to say at a certain point in time, the beneficiaries can change the trustee. So there's a fair amount of flexibility, but the one thing you don't want to do is just casually make yourself a trustee, because oftentimes that will undo benefits.
John, let me ask you a question. I'm going to give you a sort of case example here. And if I came into your office and I said, a friend told me I should look into a trust, I'm presenting as single, no kids, 65, 2 siblings, not very close to, maybe a couple of nieces and nephews that I went to their graduation and gave them some money, which was the first time I had seen them since their birth because they live in other parts of the country. And, you know, maybe a total net worth of around $500,000. What would be your initial inclination with regard to my need for a trust? And what other questions would you have for me in order to advise me?
Okay. I probably, at one point, for that particular person who we're talking about the trust, I'd probably say they're relatively young and maybe not ready to lock things up and say, this is going to go to my brother or my sister or my niece and nephew, because it sounds like there's not a lot of connection there. So we find oftentimes people in that kind of circumstance will say, well, I'm going to do something for charity with my assets. Okay, and I don't push charity, but you certainly might want to consider that if there's not a lot of strong family connections and relationship. Okay, so that person, I would think, we might look at their whole situation and say, were there any charities that they were particularly benefited by, or their parents or their family members? And there's nothing wrong with having assets transferred to their brother, sister, and niece and nephew, but sometimes you want to have them just think about a broader perspective and maybe cast a wider net in terms of their asset base.
Now, another example, which is kind of the opposite of that, what if somebody came in, they presented as a married couple, late 50s, 3 kids that are in their mid to their early to mid 20s. One of the children has special needs. The couple's net worth is about 4.5 million. You know, what are some of the things you would want to ask them or consider, and you know, maybe staggered distributions at different ages, career plans, things like that. What would you want to know from those people, and what kind of advice would you be giving them?
Okay. Well, they have a key item that says, yes, they certainly should have the trust for the benefit of the child with special needs. And that trust could either be one they set up today, or it could be one that they set up under their will, because as long as they're around, they'll probably be able to take care of and help the child, okay? The big cliff problem is when parents die oftentimes, the child with special needs who's been living at home under their care is left in a quandary, and the rest of the family has to figure out what to do. So it may be that they would say, we want to set up a fund for that child now, which could be done by a trust, because that child's in a different category than our other two children. Okay, the other two children don't have the special needs, so they may fit into a staggered payout kind of trust where you'd say, I'll give some of the money to them when they're 30 and some when they're 35, balance when they're 40. And the goal of some of that is, I think, you're balancing out giving the children money all at once. So if a child makes a mistake and invests it on offshore strip mining ventures in British Guam, and they learn from that mistake, then they get more money later on, and hopefully they've learned their lesson to follow the end you've guided them, okay? And some trusts actually will have provisions that say if a child, in the discretion of the trustee, is spending money frivolously, or if the child winds up having a substance problem, then the trustee is allowed to change the provisions of the trust and say, all we're covering now is cost of going to a clinic or something, okay? So there's things that they could do, and I would say for them, again, it comes down to balancing out. Oftentimes in a case like that, one of the quandaries that parents have is if one child has special needs and she needs more than the others, sometimes the parents will feel, well, maybe we shouldn't do that. And I kind of try to say, well, no, you should do what you think is right for that child. And if that child has a special need, then maybe she does get more of the asset base.
And then going back to Christina's question too about trustee, the siblings, in my estimation, would be somebody that you would strongly consider as trustees, depending on the level of responsibility that they were demonstrating.
And certainly they're your children, so you have a good handle on them and you know who they are. So you would know if they have integrity, and you would know if they can handle finances. In some cases, what we find is one child is a very good investor, but he or she would not be indicated to be the person in charge of paying money out for special needs. So sometimes in that case, you'd say, well, I'm going to have my son and daughter as co-trustees, knowing that you need the two of them to cover the various bases that you want to have, okay, for that particular child. So that instance where you have a child with special needs is usually an area where you want to give that due attention, okay, and not be too concerned if one child gets a little bit more than the other two, because everybody comes into life and we're all equal, but everybody has different outcomes. No matter what you do, there'll be different outcomes. Okay? So I don't, does that help, Christina?
It does, and we have about 2 minutes left, and I'm going to throw in just a couple of questions. What is a living trust? And then you could speak a little bit about how much setting up a trust costs.
Okay, good question. A living trust is another name for a revocable trust that a person creates during his lifetime. The living trust then isn't designed so much to provide any estate tax benefit. It's really just a mechanism to balance out a person's assets and say, how should assets devolve? Where should they go to? Okay. And so a living trust is like a revocable trust. Okay. So let's talk a little bit about cost, because that's a very good question. It's a hard question sometimes to be responsive to. We talked earlier about somebody that may have only 150 or 200,000 of assets, but she may have a child with special needs. And then somebody else may have $5 million, but they have no special needs. So that person with 150,000 may be a good candidate to have a trust. And you try in a case like that to mitigate and bring down the cost of the trust vehicle. So now if we have a trust, usually you have to deal with an attorney to prepare the trust. There's a cost of a trust that can be anywhere from, I would say, a minimum of $1,500, $1,200 to a lot more than that. It's part of a complete estate plan arrangement. And then in some cases, a trust needs to file an annual tax return. So now we have an attorney at the front end preparing a document. We have a need for a trustee. We also may have a need for a tax return. So what you want to always think about are these cost factors, because if you take the 150 and load against it all these costs, that's not a good thing the beneficiary. So you're looking in a case like that, maybe you find a family member to serve as trustee, okay? And I think the cost, just to come back and try to sum that up, a cost of an estate plan, which should include a power of attorney and a healthcare directive, okay, could range anywhere from $1,000 on the low end of the scale, but it could be $5,000-$10,000 depending on how much planning and how many special trusts somebody wants to use, okay?
So it's a range.
A range.
$1,000 to tens of thousands of dollars.
Well, not in fit. But
Hopefully.
Heather, it's 101. I'm
All
going to
right.
turn it back over to you.
I'm gonna wrap it up. I hope that today has been informative for everyone. Today's session will be available on my website at morrissurrogate.com next week. And if you have any other subjects that you're interested in knowing about, please feel free to contact me. As always, you can reach out at surrogate@co.morris.nj.us. John, I want to thank you for being our guest today. You're a wealth of knowledge, and I might ask you if you enjoyed today at some point in the future to come back, because this topic is so deep.
Yeah.
And to me, it's a favorite topic because it's one of the ways that attorneys can actually intervene and make a positive difference in somebody's life and future that goes on to benefit children and grandchildren for generations to come. And they can be greatly harmed if they don't go and get the right advice. So I think this is key. Again, I hope everyone enjoyed this. Thank you all for joining our session today, and have a wonderful day.
thank you, Christina, for making it work.